Well, good morning and welcome to this panel on Congressional Gridlock and the Executive, a battle over nominations, recess appointments, and the use of the filibuster. We're going to proceed somewhat unusually. Rather than starting with set pieces from each of our four very distinguished panelists that are designed to put you to sleep, we're going to proceed in more of a conversational manner. And I want to encourage all of the panelists to really take that to heart. This is supposed to be a free-for-all, so jump in, say what you really think, ask questions if you think they need to be asked. Please do. And after we finish that portion of the panel, we'll open it up to the audience for questions. There'll be a microphone to be handed out, so please wait for that before you join the fray. Also, please remember to turn off your cell phones or put them on some mode that doesn't make noise. Okay, including panelists, I guess. Okay, so we have four distinguished panelists to talk about this topic. First, at my far left is Lou Fisher, who is with the Constitution Project, following many decades with the Library of Congress and Congressional Research Service, when Lou was not just an academic expert in separation of powers, but a real practical expert in separation of powers, answering questions about congressional and executive power in a whole host of live controversies, as well as in academic journals and books. To say that he is prolific doesn't begin to do Lou justice. After Lou, we have Marge Baker, who is with People for the American Way, and she is in the trenches fighting and advocating on nominations every day, and so she brings to us, like Lou, a very practical range of experience on the topics we'll be discussing. After that, we have two academics who thankfully actually have real practical experience in this as well. First, Professor Michael McConnell from Stanford University, who previously served as a judge on the 10th Circuit Court of Appeals and so knows firsthand exactly what these processes we're about to talk about are really all about. And then lastly, Professor Mike Gerhardt from UNC Chapel Hill, who, in addition to being a leading academic voice on these topics, has served as counselor to Senator Leahy on the nominations of Justices Sotomayor and Kagan. So we have real practical and academic experience up and down the panel, so it should be really a great discussion. A discussion of our topic, again, gridlock in the nominations process. And clearly there is gridlock, right? There are, with respect to judicial nominations, there are more vacancies now than there were when President Obama took office. Over 30 of those vacancies have been categorized by the judiciary as emergency vacancies. And so there's a real problem. Now, who's to blame? Some say Congress for its obstructionism, others blame the administration for being slow to make nominations and for not pushing for those nominations it does make. I want to start just by asking Professor Gerhardt, in the words of the famous constitutional theorist David Byrne, how did we get here?
Well, I flew. I will not comment on the irony if we can't all agree there's gridlock. So I'm going to begin with the supposition that we can at least all agree on that. And if there's disagreement, that's a whole other panel. But let me also thank Neil and the ACS for the opportunity to be here. It's a great pleasure to be here, probably in more ways than you might know. I've just finished several weeks of bar review lectures. And so it's nice to be in front of a friendly audience. Thanks, Garrett. So let me try and answer Neil's question in the 45 seconds I've got left. Of course, the question of how we got here is an important one, and it's just intertwined with all sorts of things. So let me just briefly mention what I think are a number of different factors which seem to have created somewhat of a perfect storm. that we now seem to see as it relates to appointments. Although I should say at the outset, we've seen worse. And that may be useful to keep in mind. We're not at a locale now that I think is as bad as some situations we've seen in the past, though we have forgotten to some extent about them. So the first factor I want to mention is something that's been with us all along, and that's constitutional design. I think the Constitution, by design, creates an appointments process that both invites conflict and invites accommodation. So when you give the President and the Senate each power over appointments, you can sometimes expect them not to agree. You can expect them to come into conflict, but then there's pressure also within that system to accommodate. It gets even more complicated when you recognize that the Senate, by design, isn't necessarily set up to be a place where you can get things done. Don't forget that by design as well, I think, we've got a government that is structured to some extent not to do things. Things are designed to some extent to make them difficult. So that design isn't not just in the background, it defines a lot of what we're going to be talking about. Second thing is a dynamic that's been with us for quite a while, and that's payback. So a lot of what we see going on, I think, in the appointments process, including judicial nominations, consists of a great deal of payback. And there's a bit of a blame game here, and I won't enter into it, but you know who you are. In any event, I think that you see a little bit of that with the recess appointments. I think you see some of that with the judicial nominations. And let's not forget that we meet in the shadow of Robert Bork's defeated nomination. It's 25 years since then, but I don't think anybody's forgotten. And you don't have to sit through a hearing very long before you hear that invoked. Not to mention the blockage of Miguel Estrada's nomination to the D.C. Circuit. But I think there's enough blame to go around that, again, we shouldn't forget that to some extent what we're seeing is a fairly widespread and intense game of payback. I think a third factor is a perennial battle as well, and I noticed the word battle as part of our title here. But it's a perennial battle, I think, in American politics, and particularly when we're talking about appointments, to fight over what counts as the mainstream, to fight over how we define the center and how we define mainstream. To some extent, these battles are designed, I think, to try and push the president, perhaps the Democratic Party, more not just toward the center, but to the right of center. Not to take as a given that there is a sort of a court ought to simply exist with this number of Democrats and Republicans that's got on it currently. So I think that the fight over trying to define the middle is a perennial one, and that's a little bit of what we see here. It's ideological as well as partisan. Another factor is I think we should not forget that the country itself is deeply divided. There is, I remember when I talked to the Federalist Society, its last national convention, where, by the way, people are always quite hospitable and it's a nice place to be, that I said in my remarks there that I felt I was part of a dying breed, and the reason I said that was because of the fact that I often think of myself, if I'm forced to think of it myself this way, as a moderate. And the way in which we see divisions in American politics and elsewhere today, moderates are, at least in my view, somewhat of a dying breed. People are forced, pulled, attracted to some extent to polar opposite positions, and that's something else we're seeing. And don't forget as well, we're in an election year. That's always a fun time when we're talking about appointments. Yet two other quick factors I'll mention. A lot of these fights over nominations happen below radar. Most Americans are not aware of them. Most Americans don't care about them. I still love the way that, I'm now in North Carolina, the way that Senator Jesse Helms once described the battle, saying, if people in North Carolina, particularly in Raleigh, wouldn't recognize a federal judge if he were walking down the middle of the street. And I often thought to myself, why is the judge walking down the middle of the street? But anyway, won't be a judge very long, by the way. But in any event, the point I think he was trying to make is that this is not something that most people care about. Their votes are not really going to turn on it. That makes it easier to fight. And the last factor, which will sound a bit flip, is actually not meant to be flip, and that is because they can. I think that to some extent people obstruct because they recognize that under the current political circumstances, obstruction is a bit easier. Democrats, quite frankly, I think, have a larger political agenda. That means they have more things, they've got more balls they've got to keep up in the air. They can't spend all their coinage over nominations, and so that makes it easier to fight over a series of nominations. So those are different factors. We're going to find out shortly why they're all wrong, but that's at least my quick take on that. Let me also just mention briefly before I finish that, of course, we haven't talked as much about the constitutional arguments, and I'm sure we will, over recess appointments. That's an interesting and sharp divide. We'll talk about the filibuster as well. We have lawsuits over both the filibuster and the recess appointments, and I just want to make a couple comments about the lawsuits, and then I'll finish my remarks. I do think it's rather ironic that we heard in the last panel about not just the gridlock, but how everybody wanted to sort of get away from the court. And our program was set up to some extent to talk about the Constitution outside the court. But what you might want to pay attention to today is how quickly everybody gravitates toward judicial review. And it reminds me of a time, I had great honor years ago to be working with Senator Daschle and the Democrats, and this is a time when there was some consideration what they used to refer to as a nuclear option. And I remember standing with him in a room, and I said, so what's this fight all about? And it so happened there was a window right next to us, and he pointed where I thought he would point, and he pointed over to the Supreme Court buildings that that's what it's all about. So to some extent, one reason why we get gridlock like this is because of, I think, an assumption and maybe even a hope that a lot of these issues end up in court. Personally, I would hate to see that. I think that the Constitution outside the court is an area that needs invigoration. It needs protection. I think to the extent we defer to courts and expect courts to solve our problems, democracy suffers. I think that we are a stronger republic, and I think institutions work better when they recognize and have to take responsibility for their own constitutional decision making. So that counts for recess appointments, it counts for filibusters and other things we'll talk about today. And I personally think, again, because of standing and political question problems, some of these lawsuits, at least against the filibuster, will not likely succeed. And I say that with some, I suppose, regret, because the lawsuit against the filibuster was filed by one of my oldest and dearest friends, Emmett Bondurant. But Emmett and I have talked a great deal about this, and we remain friends, though if you know Emmett, he wouldn't give an inch on his position, and if you know me, I'd probably give an inch, but yeah, that would be about it. But I hope that sets the stage a little bit, Neil, and I'm happy to jump in whenever I feel like I've got something to contribute. Thanks.
Okay. And I want to skip to Marge, because I know, Marge, you disagree with the point Mike opened with, that this is not unprecedented.
Yeah, can you hear me? I do agree with the premise that part of the way we got here is this is about payback, and I think that payback has now descended to a level that we haven't seen before. So just some points that I think are worth considering. Just the sheer number of filibusters of judicial nominations has increased. Now I'm talking about judicial nominations. I think it's also true of other issues as well, but of judicial nominations it's increased manyfold. During the entire 8 years of the Bush presidency, there were 18 filibusters. During the first 3.5 years of the Obama presidency, there have already been 27. So the sheer number of filibusters, the sheer number of efforts to block judicial nominations, forcing a cloture petition to be filed, has increased. It's also extended to district court judges. During the entire Bush 8 years, there was one district court judge filibuster. And during the 3.5 years of the Obama administration so far, there have been 19. There's now a filibuster of non-controversial nominees. So these aren't filibusters based on ideology. These are filibusters literally because they can. Many of the nominees for whom cloture's been filed and their cloture votes forced end up getting approved, either unanimously or with 1 or 2 votes against them. So the minority is forcing a process of going through a cloture petition, forcing cloture votes, only to essentially vote overwhelmingly for that nominee. So this is not, again, about ideology. It's not about extraordinary circumstances. This is because they can. And on that latter point, there is a sense, and I think it goes to Professor Gerhardt's notion that sort of the middle is being redefined, because nominees are being labeled as extraordinary, controversial, like David Hamilton, who was nominated for circuit court seat, who had the support of the local federal society. I mean, this is somebody who just under no circumstance could be considered extraordinary. It was the first circuit court nomination the president made, and he was filibustered. So I do think it's unprecedented. And then I also have to say it's happening in the context of other obstruction that's going on, some of the silent obstruction. And it's not to say this hasn't happened under other administrations, but it's going on now, and I think it's going on to a greater extent. You have senators, for example, in terms of the process of getting names to the White House, who are refusing to go even begin their process of considering nominations if it's a future vacancy, which totally defeats the point of having advance notice that there's going to be a retirement on the court. You have a refusal to return blue slips in circumstances. Blue slip is the process where home state senators sign off on proceeding forward on a nomination. And there are a number of circumstances in which blue slips are being withheld for reasons that seem strained. So Alyssa Kadish for the District of Nevada is being held up because she, I think, appropriately and accurately answered a questionnaire about whether there was a Second Amendment, an individual right to bear arms in the Second Amendment, pre-Heller, and she the senator is not returning the blue slip because Senator Heller is not returning the blue slip because of that position that she took, which was essentially saying what the overwhelming case law was at that time. You have delays in committee. You get routine. There's a process in committee where a nomination is put on the calendar for the committee to consider, and then any senator on the committee has a right to hold over that matter. Typically, it's because they have questions to ask about the nominee. Well, what's happening now is routinely, every time a nomination, judicial nomination goes on the calendar, essentially every single one of them is held over. I just want to make sure I have this right. This was as of May 4th, so it may have changed. Glenn Sugamelli can tell me, I'm sure, or wherever Joe is. But all but 5 of the more than 150 nominees, judicial nominees, that have come through committee, of all the nominees that have come through committee, have been held over for at least a week. And if you're talking about that holdover coming at a time when there's a recess, it could be 2 or 3 weeks before that nominee gets considered. So there's delay, literally getting the nomination considered in committee and then on the calendar. And then delays on the floor. President Obama's nominees are waiting literally 4 times longer once they get to the calendar to be taken up compared to President Bush's nominees. And then the last point I want to make. So the filibusters, once the nominees get to the floor, are happening in the context of all this other obstruction that's already happening. And then the last is the newly announced decision by Senator McConnell. It's not clear yet it's the position of the Republican caucus, but it is the position of Senator McConnell to invoke what we call the Thurman myth, which is that in an election year, nominations are cut off. Now, it is true that in an election year, consideration of nominations slows down. But what's different about the invocation this time of that myth, that mythical practice, is that it's being extended to all circuit court nominees regardless of whether or not there's any controversy about them. And so this is catching up in the process. Nominees, with 3 of the 4 circuit court nominees currently on the calendar who under this myth will not get taken up, have strong bipartisan support from their home state senators. In fact, Senator Coburn said about the nominee to the 10th Circuit, Bacharach, that it was stupid not to take up this nominee. And you have Senator Snowe and Collins are quite upset that Kayada, who's nominated to the First Circuit, is not going to get a vote under this. So you have strong bipartisan support for nominees who are getting caught in this invocation of this mythical practice that you don't take up nominations at some point toward the end of an election year. And also, just the final point on that, this practice, even if it were a rule, if it were accepted practice, is being invoked much earlier than in previous administrations. Between this time and the election year under President Carter, there were 5 circuit court nominees approved. Under Reagan, there were 7 in his first term and 2 in his second. Under Bush 1, there were 7. Under Bush 2, there were 3 in his first term and 2 in his second term. So these are circuit court nominees who, post June 13th, when this announcement was made, in previous administrations, got votes. So this process, whatever this is that's being invoked, is being invoked much earlier. So I can go on and on, but I do think, I do agree with the proposition that this is a process of payback that's gotten us here, and I do think we've gotten to a place that is really unprecedented and frankly really dangerous in terms of the ability of our courts to function. In the 10th Circuit, there are 2 of the 12 seats are vacant. The workload is being handled by senior judges, one of whom I believe is 89 years old and the other is 96 years old. I mean, this is not a problem without its impact. And what's being held up from those senior judges not having to take on more workload, what's forcing them to take on that more workload is the failure to confirm a nominee who doesn't have any opposition. So it's gotten to the point that something has to be done, and I know we're going to be talking about what those possible solutions are, but I do believe we're at an unprecedented and kind of dangerous place.
And Professor McConnell, having lived through it, does it seem worse to you now, or is this just kind of the game?
Well, you know, I have to say that both Michael and Marge are right. This is not unprecedented, and it's worse than ever. How can that be? It can be because it has progressively gotten worse with every administration dating back to Jimmy Carter. This is not what I thought I was going to be talking about, so I don't actually have the numbers in front of me, but I can give you the general drift of the numbers. There are two ways to measure obstruction of judicial nominations. One is to ask how long a nomination takes before the confirmation takes place, and the other is to ask how many nominees are either defeated or run out or lose because you run out the clock. And if you go back to Jimmy Carter's administration, when things were humming along and both district court nominations and circuit court nominations were regularly, routinely processed and confirmed in a matter of a few months. Every administration since then has been worse than the one before. Marge mentioned some specifics. I think she's right about one important point and not quite right about the other. She's very right that there's a new thing in the extension of this to district court nominations. Actually, if you look during the Bush and Clinton and early second Bush years, not only were district court nominees not caught up in the problem, they actually went faster. That is, they were processed faster and with fewer problems than had been historically true. This was because Judiciary Committee chairs liked to be able to point to their statistics. Oh yes, we are confirming judges. And the easiest way to do that when they're in fact not confirming Court of Appeals judges was to point to how fast they were doing district court judges. That has changed, and I agree with Marge. And by the way, I don't disagree on the normative side of this at all. But that is a major escalation in this matter. I don't quite agree that the filibuster is being used more frequently now than it was under George W. Bush. The question, I mean, this is a terminological question. I don't count it as a filibuster if a single senator has a hold and forces a floor vote on someone. If when it gets to the floor, the opposition party does not actually vote against. And as Marge pointed out, there have been many more cloture votes, and I suppose you can technically say those are filibusters. But if the opposition party just confirms the nominee, that's not a big deal. It's just a matter of using a little bit of floor time in the Senate. What I think is really different now is that for reasons that I frankly don't understand, I'm not a politician, this majority, Harry Reid, does not want to bring nominees to the floor. If he would simply bring them to the floor, more of them would be confirmed. My replacement on the 10th Circuit was completely non-controversial, supported by Senator Hatch, and it took him 18 months, I think it was, to get confirmed because Harry Reid wouldn't bring him to the floor. Orrin Hatch was complaining that the Democrats were not bringing him to the floor. During the George W. Bush period, when there really were serious filibusters, they brought him to the floor. I think Miguel Estrada came to the floor 5 different times. They said, if you guys want to obstruct, we want you to do it publicly and force you to give your reasons and take a little bit of heat for it. For some reason, the current majority doesn't seem to take that view. So I think as to filibusters, actually the problem is much less than it was. There have been a few. Goodwin Blue, for example, was a real filibuster, but I think the real filibusters have gone down a little bit. But that said, we still have a very serious problem. Now, I'm happy to say that. I've been saying that. I said that under George W. Bush. I'm very happy to have new allies. I doubt very many people in this room were particularly upset about the degree of filibustering and obstruction that was going on under George W. Bush. And I would like to invoke the most important constitutional principle in our system, which is what is sauce for the goose is sauce for the gander. And even now, I don't think that it is, well, let me just say one more sort of good government goo-goo point that everyone may agree with, I hope, which is that this really does matter, not just because of the slowing down. Actually, there are 3 senior judges in the 10th Circuit who are quite much younger than that and doing a great job. It's not, the real problem is what kind of a judiciary we are going to have. This country has been blessed by having judiciary made up of people who are very distinguished and often courageous lawyers in various walks of life. The trouble is, if you are distinguished and if you are courageous, you will have made somebody mad, right? And the idea that you have to get 60 votes in the Senate for confirmation essentially means that presidents are going to be looking to promote a different kind of person to the courts of appeals and maybe even the district courts. Now, they're going to promote magistrate judges to district courts. They're going to promote longtime district courts or state court judges, people who have never really done anything that gets folks terribly excited. I think that's going to change the nature of our system. Back when folks like you were defending the filibuster against Court of Appeals judges, the usual argument was this: it keeps out the extremists, right? And so by requiring 60 votes, you make sure that President Bush had to nominate people who are reasonably within the mainstream. I thought that was an inaccurate argument then, and maybe you'll be more open to my refutation today than you were back then. First of all, that is not the way it works in practice. The people being filibustered were not the most extreme. By and large, they were the most capable and distinguished and well-known. If you look at at one point, the Court of Appeals nominee who had the largest number of votes against him and still was confirmed in history was Alex Kaczynski, right? Among the judges who had the longest slog to get confirmed were Posner, Easterbrook, Willie Fletcher. These are not extremists. these are among the best nominees. And typically, what happens is, the parties want to knock off the most capable of the other team, so that they don't have, Supreme Court nominees, and there, by the way, having been confirmed by unanimous consent, that just shows how poor a nominee I really was. But secondly, we have an automatic protection against extremism. The presidents don't name extremists anyway. I mean, Democrats may think Republicans do it, and Republicans may think Democrats do it. Both of them are just overheated. Presidents don't name extremists, but even if they did, we have an automatic control for this, because the presidency shifts hands. In my lifetime, every 8 years, we've had a different a party controlling the presidency, with the single exception when Jimmy Carter was such a bad president that he gave the Republicans an extra 4. But with that one exception, it's been every 8 years, and in an 8-year period, a president names approximately 40% of the Court of Appeals judges. So given that, it's actually a better system to have something more like a rubber stamp, where the president names the best people he can for his team, and then when the other team comes in, that they'll get the best people that they have, and the result of that is going to have a judiciary where you have, interesting, significant, maybe even controversial figures who are going to be able to contribute to it. But one final point here is, however much consensus there might seem to be on this question, I am not convinced that anyone in Washington actually wants to do anything about this problem. That is, yes, Democrats today would love it if Republicans would stop obstructing Democratic nominations. But do they want to change the rules such that they will not be able to obstruct Republican nominations in the future? I'm not quite so sure that they do. Here is my practical suggestion. Why don't we those of us who, on both sides who might have some influence on the matter, get behind the following idea. Let's adopt rules that will go into effect, I don't know the right number, 3 years from hence, 4 years hence? Enough in the future that we don't know, we'll be behind a veil of ignorance and will not know, is it going to hurt us, is it going to help us? Enough in advance that all the tit for tat and the playback, the payback is gone, and then maybe we could sit down and think, what should be the role of the filibuster in judicial nominations? 0? Should there be none at all, or how should it work? Should it allow the minority to slow things down, but maybe not end them? And by the way, I think worse than the filibuster is the hold and the blue slip. If 40 senators are against you, at least there's something going on. But to allow idiosyncratic individual senators to be able to block the process is really zany. And if you think, David Hamilton, well, he wasn't the blue slip problem. Stephen Six in Kansas was a terrible abuse of this, in my personal opinion. But for everyone we could name from this administration, there's a Carolyn Kuhl or a Peter Keisler or another from the previous administration. I think good government reformers on both sides, if we could only get behind a veil of ignorance, would surely eliminate this opportunity for abuse.
Okay. Thanks. And I think just to sort of amplify the point you were making about the filibuster, it's interesting in the lawsuit that Mike mentioned, filed by Emmett Bondurant, no senators have joined that lawsuit, right? Which I think is because they all want to have the filibuster when they're in the minority, which is exactly your point. Lou, I'm curious to know your views about the filibuster, whether you see it being abused, whether you see it as perhaps unconstitutional, regardless of whether a court could declare that it's unconstitutional, whether you think sort of constitution outside the courts, it's unconstitutional.
I don't think it is. I think each house has its own procedures and can go about its business as it likes. I thought Michael McConnell made the point that I've wondered about in recent years. If I don't like someone to threaten a filibuster, I would want them to come and have a real one. That means day and night, bring out your cots, bring out your snacks and so forth, and have at it. And let the public see what your argument is. It might be very embarrassing to have it done. But just to have one person threaten and then not to come to the floor, I think that's the weakness. And it could be easily corrected by what a majority leader does. So I don't know why. I agree with Michael McConnell. Bring them out and have a fight and see who looks better. And I think some people would look very poor, whatever their initial objections were. So a filibuster, I don't have any objections to it. On the blue slip, I think it goes back to, from the beginning, you had an agreement that in the nomination process, you would depend a lot on senators knowing people in their area, in their state, and they would have a quote hold then. And if they didn't like someone, the other senators would defer because it was in their interest as well. So I don't see any objection to that, and now it's been enshrined into the blue slip process. It just means if you're from your state, you have a veto over it. I think it works well.
Well, yeah, Marge?
Just a few points, if I could.
Sure.
In responding to some of the comments here. One is I totally agree that part of the process right now is the obstruction that's going on is hidden. And part of that is because one senator, because the rules permit the Senate to be so tied up for so long, if in fact, to work through the cloture process, and because the Senate, quote unquote, wants to do other business and there's other important business to do, there is a limited amount of floor time. That is not in any sense justifying. We are among many who would like to see the Senate spend more time calling the question and, in fact, forcing votes on those who have been who are being held up because of the threat of a filibuster. I do disagree. I think it's important. Those are filibusters. There are hidden filibusters, but nonetheless, the fact that a nominee is being blocked from consideration, I think, is a filibuster. And if it requires a cloture vote to get it to move forward, it should get done. I think what we've seen, in fact, is at the end of last year, and then again earlier this year, when Senator Reid did, in fact, file cloture on a large number of judicial nominees, it broke things open because it can't stand the light of day. It absolutely can't stand the light of day, and that's when we've been able to make progress. But it shouldn't take that long, and it is partly the willingness of the minority to filibuster in a number of circumstances it is doing, including to district court nominees and including to non-controversial circuit court nominees, that the problem is. I mean, we will differ over whether or not the filibusters of the Bush nominees were of extraordinary or extreme nominees. I have some difference of opinion, for example, with nominees like Janice Rogers Brown. But the point is that what's going on now is a routine willingness of the minority to entirely hold the Senate entirely up in order to get these nominations through, regardless of the merits of the nomination. And that's got to stop. And I think one way to do it is there are things that the majority leader could do right now under the rules. And there are some rule changes that could make sense, that could streamline the process and permit and create an atmosphere where those who are obstructing are forced to hold the floor, forced to affirmatively get votes to continue obstructing. There's lots of ways in which the rules could be changed to make that better. And then the last point is I'm not sure it's true that no senator wants to change the rules. I mean, there are a number of senators who actively are pushing proposals, Senator Merkley, Senator Tom Udall, and others, who are actively pushing proposals to modify the Senate rules in order to essentially make it harder to filibuster, harder to keep the Senate from operating, for one or a small number of minority members to keep the Senate from operating, which I think probably would help move things to a better place.
Okay. Right, and in fairness to the lawsuit that's been filed, the claim isn't that the filibuster sort of generically is unconstitutional. It's that the filibuster we have is unconstitutional, and it's unconstitutional in part because it's backed by a requirement of a 2/3 vote to amend the rules of the Senate. So you have this sort of double supermajority requirement. And as a practical matter, that's...
Well, may I just comment?
Sure.
That it may very well be that a two-thirds requirement to change the rules is unconstitutional and the filibuster isn't. But until there is a majority vote to change the rules, it's not ripe and we don't have a case.
Right, right, and and we might need a senator to actually file the lawsuit, right, in order to have standing.
The justiciability problems with that lawsuit
Right,
are insuperable.
Are tremendous, although again, pointing as Mike Gerhardt did, to the Constitution outside the courts, right, we don't have to worry about justiciability issues as we talk about them, right? We could look at the Senate and identify them as violating their constitutional oaths by refusing to either provide or withhold advice and consent, which is, it would seem, their duty under the Constitution. So regardless of whether a court can make that declaration, perhaps we can and should, which I think then brings us to one of the issues that we're supposed to be talking about, so let's get to it. Right, so you're the president, you're confronted with this kind of obstruction. What do? Well, one thing presidents do is make recess appointments, right, to get around obstruction, right? So we're getting to where I think you wanted to go, Mike. President makes recess appointments, including of judges, but not only of judges, right? And our discussion here has mainly been about judicial nominees, but certainly obstruction has not been limited to that area. Right? I used to work in the Office of Legal Counsel, so I tend to think about things sort of from a very parochial view of the Justice Department. It took 2.5 years to get a confirmed head of the Office of Legal Counsel in this administration. It took over a year to get a confirmed head of the Office of Legal Policy, right? And these aren't life-tenured positions. These aren't positions with authority to do anything other than what the president wants these officers to do. And yet, these officers are being obstructed in their nominations, right? So what are you to do if you're the president? You need people in offices to run the government, so presidents make recess appointments. And one sort of very high-profile instance of this was our keynote speaker last night, Richard Cordray, right, nominated to head the new CFPB, who's opposed not on the merits, but rather as a way of preventing the Consumer Financial Protection Bureau from actually getting up and running and doing its job, right? Which seems like another constitutional violation. If Congress doesn't like the CFPB, it can repeal it. And if it can't repeal it, then the president's job is to take care that the laws be faithfully executed, which requires having a director of the CFPB. So the president goes ahead and makes that nomination during a recess of the Senate. Right? This all seems perfectly right and legal. Doesn't it, Professor McConnell? Of course not.
So here I probably take more issue. First of all, you know, Cordray, whom I've known for years and think very highly of, it's true that he was not opposed on his personal merits, but he was opposed on the merits, namely that the Republicans took the position that it was dangerous for that extraordinary degree of discretionary power to be vested in an administrative agency of only one, with only one head. So they were using his nomination as leverage to try to get the majority to agree to amend the statute to create a multi-member agency along the lines of the ICC or the NLRB or the FCC or any of the others. So it wasn't just a matter of completely trying to avoid this, but the recess appointment and then the other two appointees at the time. So President Obama named 3 recess appointments. The other 2 had been sent to the Senate 2 days before. So the Senate had had no opportunity whatsoever to consider them. So these were not actually, these 3 recess nominees were, especially the latter 2, were not responses to senatorial obstructionism. It was, this was a rather brazen act to push the envelope of executive power. And I have to say, I think on this particular constitutional question that the answer is pretty clear. The president cannot name recess appointments except when there's a recess. Now, the OLC released an opinion in which they took the view that the Senate was in fact in recess because the president could ignore the fact that the Senate was meeting every 3 days in what are colloquially known as pro forma sessions. And, that in the abstract, that might be an arguable proposition. The Senate meets, only a couple people are actually there. They don't do any business. Maybe it's a total fraud. But we have to be consistent in our application of constitutional principles. And it so happens that pro forma sessions are used for a number of different purposes, and they are in fact recognized as real sessions of the Senate, and as not creating an adjournment. And so, first of all, pro forma sessions are used to pass legislation. It was on December 23rd, President Obama's most important legislative proposition before the Congress at the time was approved by the United States Congress during a pro forma session of the Senate. He then signed the bill. He knew it was a pro forma session. He signed the bill, which indicates that he believes constitutionally that he was sent a bill that was properly passed by Congress. Now, the test in the OLC opinion, and it has plenty of precedent for it, is whether the Senate is capable of acting on the nominations. Well, if they can pass legislation during a pro forma session, they can surely act on a nomination during a pro forma session. But that is not all. There are two other ways in which pro forma sessions are used for constitutional purposes. One is that Article 1, Section 5 provides that neither house can adjourn for more than 3 days without the consent of the other. This is satisfied usually not by obtaining consent, but by instead having pro forma sessions. This goes back, I believe, to 1947 that they've been doing this. And then the 20th Amendment requires that the Congress meet on noon of January 3rd with each new Congress, unless a statute has been passed to the contrary. They satisfy this usually by having a pro forma session. All of these provisions serve exactly the same constitutional function, which is that they're all designed to make sure that the houses of Congress are there and ready and able to do and capable of doing work. I do not think it is an intellectually respectable constitutional position to say that pro forma sessions are not good. They don't constitute sessions with respect to the recess appointment power, but they are perfectly good sessions when it comes to passing legislation, meeting the requirement of convening on January 3rd, and meeting the requirement of not adjourning for 3 days. Given that, I think, extraordinary record of legislative precedent with respect to what a pro forma session is, I think that President Bush was quite correct in declining to take the advice of Steve Bradbury in the Office of Legal Counsel in the prior administration, and this president should have done the same. And I also think it's extremely likely that the courts will conclude that these were improper, and it's going to be a bit of a mess. And just one further point, it would not surprise me, this is very speculative, but it would not surprise me that if one of these cases got to the United States Supreme Court, that the Supreme Court might actually get out its copy of the Constitution and read the recess appointment clause and conclude that ever since 1924, presidents have been violating the clause by making appointments that happen during the sessions, and they might even read the clause literally and say that Attorney General Edmund Randolph got it right way back in the Washington administration in saying that what the clause means is that the president can only appoint when the vacancy occurs during the recess, not when it exists during the recess. So it could be possible that by taking an extreme position like the one that he took, that the executive may have its hat handed to it, not just with respect to pro forma sessions, but with respect to very long-standing practices.
I just wanted to add a few brief points. I know, Lou, you want to get in. I'm not going to steal your thunder if it's okay. I just wanted to add a couple points, maybe initially responsive to Michael's last point, but then make a couple other just historical points about sort of the background that we've got that defines the kinds of concepts we're seeing. On the pro forma session point, I would just point out that one of the reasons they hold them is to keep the president from making recess appointments. The difficulty with pro forma sessions is they never end. So I would suggest that at least constitutionally, at some point there's got to be a recess. Clearly, that's what the president thought. I mean, at some point they've got to be able to take a break and have a recess, and that's defined functionally. And he used that test and made a determination. I would suggest I think he was acting in good faith. I don't know that the perpetual holding of pro forma sessions is similarly in good faith. So that is part of the dynamic that exists there. But beyond that, let me just make a couple other points. The second one, real quickly, is we found a culprit. And I hate to say it's probably true. When Mike Mansfield in 1975 created the two-tier system, the two-track system for legislation, that ushered in the kind of era we've got today. Part of the problem with the two-track system is as soon as somebody says they want a filibuster, the majority leader takes that business off the floor, they move on to something else, and there aren't any real filibusters anymore. I understand why he did it, but we can see that that was a mistake. Clearly the system works better when it's all done out in the open, and filibusters have to be maintained, and as everybody's pointed out, they're hard to maintain once the cameras are turned on. The last couple points, I agree with Mike that I think holds the real problem here. But you see part of the solution as well when the Senate agreed to not make them anonymous. So the Senate has the capability of solving some of these problems. And then the last point I just want to suggest is another problem we've got right now, which I want to link up to, is campaign finance. I left that out of my list. Political primaries are driving people more to extremes. And I think you can see how primaries are forcing even senators to take positions they don't necessarily want to take because they've got to do that to win re-election. And let me just make this point about a senator whom I respect enormously, and that's Orrin Hatch. Orrin Hatch is the person that suggests, or one of the many people who suggested to President Obama nominate Sonia Sotomayor. And then Senator Hatch voted against her. That's the first time he ever voted against a Supreme Court nomination in his very long, distinguished career. I think that's partly a result of the primaries. And there's work by social scientists suggesting that they are having an effect on how you're seeing the voting patterns on judicial nominations. But with that, let me turn it over to others.
Lou, did you want to jump in on that?
Yes, that's what I was going to talk about when I came here today, recess appointments. Let me add to some things that both Mikes have said. I think, just for the audience to be on the same page here, I think you'll find out that I have serious doubts as to what President Obama did, and I also find it completely unacceptable the strategy played by Senate Republicans. Now, these pro forma sessions started in November 2007, and they prevented President Bush from having any recess appointees. It's been going on for some time. And then under President Obama, they started doing the same thing, October 17, 2011, and they were going to do it right through January 23, 2012. And as all of you know, just a senator would come in one day, call the Senate to order, and then adjourn. It would take about 25, 30 seconds. So that's pro forma. What I find inadequate about the OLC opinion, first of all, it's very strange. It's dated January 6th. We didn't know about it until January 12th, so I don't know what was going on there. But it doesn't look as though OLC had time to do a professional job to support what it says in its opinion is very, very novel. And not only novel, but OLC says that there's a possibility of says substantial arguments on each side create some litigation risk for such appointments. So if you're going to do something like that, take your time and come out with a credible report, not do it the way OLC did it. There's something also very strange about the Cordray nomination. Dodd-Frank is enacted in July 21, 2010. Obama doesn't submit Cordray's name until July 18, 2011. A year goes by. It's true under Dodd-Frank that you can't put the director in place for at least a year. So it's a very strange provision. But it does mean that Obama could have got the name up early just so the Senate can start to work on it and hold some hearings. And he didn't do that. So in terms of any urgent necessity for it, I don't think it's there. In addition to Michael McConnell saying you cannot recess without the permission of the other House for more than 3 days, and the House never gave its approval for the Senate to recess, the Constitution also stipulates that each House may determine the rules of its proceedings. So the rules of its proceedings are not decided by President Obama, not decided by OLC, but by the Senate. This OLC and the Obama administration should have had some cause for concern because in the year 2010, the Supreme Court handed down a decision called New Process Steel, and it had to do with the NLRB. Because the NLRB was functioning under the theory that a quorum could be 2. And the Supreme Court said, no, you got 5 members and a quorum is 3. So it meant that 500 decisions by the NLRB were voided. And I think there's a big risk here that what NLRB is doing now and what Cordray is doing could all be nullified because these appointments were not constitutional. It looks like a high risk for OLC and the Obama administration. Getting to what Mike McConnell said, and Marge said this too, no one had any objections about the qualifications of Cordray. And in fact, what the Senate Republicans said, it doesn't matter who you bring up, we will prevent confirmation. Doesn't matter who, unless you do 3 things. And this, I think, is extraordinary. First of all, they said you have to rewrite the statute, get rid of the single director, put in a board of 5, rewrite the statute. Secondly, you have to rewrite the statute so that the Bureau doesn't depend on funding from the Federal Reserve, but would depend on appropriations. And then thirdly, says allow other financial regulators to provide a check on the Bureau's rules. Well, that's an amazing. Senator Sherrod Brown asked the Senate historian, Don Ritchie, do you know of anything like this in Senate history? And Don Ritchie has been there a long time. He said, I cannot think of anyone else ever coming up with an idea like this. And if you think it through, just imagine, say, when the new administration comes in, and they send up the names for Secretary of Defense, Secretary of Agriculture, various bureaus, and then someone says, we're not going to appoint that individual or anyone until you rewrite the underlying statute. That is a recipe for total crisis in American government. So I think the Senate Republicans have a theory here that's, to me, is unacceptable. Thanks.
Okay. Marge, did you want? Yeah.
Just a few thoughts, because I know you want to get to some questions. I disagree with Professor McConnell a little bit in terms of I think he's drawing a false equivalence between a pro forma session is a pro forma session is a pro forma session. These pro forma sessions happen because the leadership gets the unanimous consent of the body to be in pro forma session to do certain things. And in the case of there's a pro forma session in which legislation was passed, there was an affirmative agreement that legislation could be done. In this pro forma session that we're talking about, in which the recess appointments were made, there was an explicit statement that business could not be done. So they were affirmatively in pro forma session not to do business, and as we said, in order effectively to block nominations. So I think we have to be a little bit careful about saying a pro forma session, pro forma session, pro forma session. No, just another quick point
I
on
don't actually
holds.
think that that's correct.
That's fine. Yeah.
The resolution creating the pro forma session on December 23rd was identical to the one for January 3rd. It's just that by unanimous consent, they can do business
do
during
business.
pro forma sessions.
But-
And
but it
that,
has-
and
but it has to be
unanimous
done by
consent
unanimous
actually
consent.
means that the majority and the minority agree.
But it happens by unanimous consent, so withholding your consent, it's withholding your consent to do business in terms of withholding your consent to take on a nomination means that it's not going to happen.
But the sessions are identical.
The second point is that people talk about holds as something different than the filibuster. The reason holds are a problem is because the holds are a threat to filibuster. And because it's so easy to filibuster, those actually are credible threats. And so we can't deal with the hold situation, I don't think, until we deal with the fact that it's too easy to filibuster. And then one final point, it strikes me that to a certain extent we're talking about recess appointments and filibusters. There's a similar problem here, which is, which is that in both cases, in the case of a filibuster, our problem is that it's too easy to filibuster, so it's too easy to obstruct. And with respect to the recess appointments, what's happening is that it's essentially too easy. They're making it too easy to not do their business, right? It's too easy to go into a pro forma session and appear to be working and you're not working. So in both cases, this is about, I think, senators agreeing that they're there to get their work done and not use devices that essentially make it easier to obstruct the business that they are there elected to do.
Okay, good. I'd like to open things up to the floor for questions. We have about half an hour left. So, yeah, Jim Flug. Can you wait for? Do we have a microphone? Okay,
great. Neil, you mentioned and functioned in terms of the difference between recess appointments to executive branch positions and recess appointments to Article III courts. I think it's worth mentioning that even though, as you said, there's a long tradition of both, the Supreme Court has weighed in, or at least one member of the Supreme Court has weighed in on the recess appointments of Article III judges. Justice Stevens, in a denial of cert statement, warned the White House during the Bush administration that the fact that the court was denying cert on this issue should not be a signal that the court would go along with appointments either to circuit courts, which that particular case was a case called Stevens, ironically, and that the same would apply to appointments to the Supreme Court. Obviously, the argument is that Article III judges have a different standing, a different function, and a different guarantee in the Constitution than, as you said, the temporary executive appointees. And since that opinion, which I believe was in February 2005, there has not been an appointment either by the Bush administration or the Obama administration of an Article III judge. Footnote to that footnote, Justice Stevens in his recent book mentions that this is something he's been thinking about since Earl Warren was given a recess appointment, and he thought that recess appointment was unconstitutional.
And Neil, let me say that I don't think anyone should be put on an Article III court under a recess appointment because the value of Article III judges to have a lifetime term. So it means if you're on there on a recess appointment, you have to watch how you decide, because if you decide cases, the Senate will be watching you, maybe not want to confirm. The President of the White House will be watching you, maybe you don't want to send up your name again. So as you know, it's not just Earl Warren, it's two other justices went on, 3 justices on this. So I think not just in the Supreme Court, but any appellate, any Article III should never be done. And I would like to see the Senate, by Senate resolution, say that if anyone gets on the bench on a recess basis, that and that name comes back to us, we will not even take it up. We'll send it back at the end of a Congress, back to the White House. I would like that message to go out very clear. It's a no-no in terms of any credibility of judges on Article III courts.
Maybe just 2 quick points. One is, I actually think there have been some recent appointments of judges to the courts of appeals. I thought that President Clinton, for example, named Roger Gregory as a recess appointee. I might misremember that, but I thought he did name Roger Gregory to the Fourth Circuit as a recess appointee. And I thought maybe President...
Prior.
Right. I think
Right.
Jim's point was
Oh.
since 2005.
Oh, I'm sorry, I didn't hear that. I'm sorry. Okay, just disregard everything I just said. Secondly, I think the recess appointments clause comes, the way the structure unfolds, it comes up as an exception to the normal appointments process. And of course, it does say all. And I would think that, but when they use the word all, one might think that it means what it sounds like. Now that's different than saying politically is it a wise thing to do, but I think by design, I think it's possible.
I would also say, Lou...
My point is that presidents can do it. You can say all means all, but there should be a check. And one of the checks I would like to see is the Senate makes it clear to any nominee, you're not going to come back on a second time for us. That's it for you.
Okay, I think it's a valid caution, although it would seem to me to apply just as well to a district court judge who is nominated to be a circuit court judge and who might sort of be timid while that nomination is pending, or to any district or circuit court judge who might be nominated to the Supreme Court, right? So if we really wanted to enforce that principle, we'd need a rule like the old canonical rule that bishops cannot be appointed to a new see. Yeah.
There you go.
You began the program by asking, how do we get to where we are? I'd like to pose that as, how do we get to where we are with the novel concept it routinely requires 60 votes to pass a bill?
Anybody?
So how did we get to the place where it's routinely required? It's because the filibuster's too easy. It's because the filibuster's too easy, and because political, because it's being done in secret. And so you have to both make it harder and make it more politically difficult to do. So I think the process, and I think there's actually agreement on this panel, that shining a light on those who are insisting on using the rules to obstruct will in fact let the political forces work so that it becomes more difficult to do politically. And then I think there are ways to simply make it more difficult to do procedurally that we really ought to investigate. That doesn't mean you have to get rid of the filibuster. I think you have to make it harder, both politically and procedurally, to do. And right now, it is so easy, literally, by saying you're going to hold something, that you refuse to yield unanimous consent to take a matter up, you can effectively insist that there are 60 votes in order to get that matter passed, no matter what. And it's a process of the political will and procedurally making the changes to make it harder.
I quite agree with that, but I would like to make 2 points. One is just a small point. There's another reason why it's gotten worse, and that is the Senate majority's irresponsible practice of not passing a budget, because under the Budget Control Act of 1974, when there is a budget that has been passed, and that's passed by concurrent resolution and cannot be filibustered, when there is a budget passed, then a reconciliation bill becomes in order, which can include tax increases or cuts, spending bills. I mean, much of the business of the United States Congress can be done in the form of reconciliation legislation, but it can only be done if there's a budget. Senate's required to do a budget. I think you folks, you have a pipeline to Majority Leader Reid. You ought to tell him pass a budget, and then the Republicans wouldn't be able to filibuster this. It's rank politics is why they've chosen not to do this. The second point is just I hope we're getting a transcript and a tape of this event here, because of all of the of this congenial consensus I'm feeling, and I wonder whether it will last. Let us just imagine for a moment that President Obama is reelected, but that he does not have 60 senators of his party. Let's imagine that he names a Goodwin Liu, or I could name any other people. I don't mean to pick on my good friend Goodwin, but names him to the United States Supreme Court. That the Republicans, for the first time in history where there's not a corruption issue, successfully filibuster the Supreme Court nomination. The first Monday in October comes. The Supreme Court has only 8 justices. There's no prospect of any resolution in sight politically because the president is not going to budge and name somebody moderate. Instead, he's going to stick with his guns, and things are and we have what looks like a constitutional crisis, and he then does a recess appointment to make sure that the Supreme Court has 9 members during whatever the next 2-year period during which they can work things out. I would just like to know how many people in this panel and in this room are going to stick to their position that recess appointments of Article III judges, including Supreme Court justices, are improper and should not be done. Because it's going to happen, unless, of course, the election goes the other way.
Yeah, Shahid?
So this is a fascinating discussion, and I appreciate having a chance to hear it. I'm concerned and curious about the impact on checks and balances in 2 different dimensions. One relating to the independence of the judiciary, and I'm picking up here, Judge McConnell, on your comments about the timidity of judges for which we're selecting through a process that has grown so institutionally risk-averse. And then the second, picking up on Neil's comment about OLC, I'm thinking about particularly Dawn's nomination and the idea of OLC providing an intra-executive check and the erosion of that check through the Senate's failure to, in that particular instance, confirm a specific nominee, but just we can abstract it out from that particular instance. And is the independence of the judiciary being compromised, separate from the administrative problems in terms of the increasing caseload and everything else? And then are we also eroding the intra-executive checks by similarly forcing a certain moderation or timidity among the nominees that are being considered for those high-level executive positions?
Let me at least address the first point you made, and I did want to agree with Michael's point. I actually think one of the things that doesn't get noticed enough is the fact that I think a lot of the obstruction that's occurred over the last, you can just put in your number of years there, is designed to make it harder for distinguished, courageous people in public life to get on the bench. I think that is, there's not a strong enough word to say how regrettable that is. I mean, that is, it's a shame. And it does then drive presidents to try and pick people, I'm not saying who are not qualified or anything else like that, but who simply have lacked, who in a sense are being punished. He's going to choose folks who he thinks are not going to get stopped, and therefore the people that get punished will be the people who actually did serve more distinguished lives in public. I think you see that increasingly. And I talk about this at law schools at times because I think I get questions from students saying, well, does this mean I can't be publicly involved, or what's going to, all you can say is, look, there may well be people that will try and punish you for the positions you take publicly, and I think it turns out to be conservatives or liberals. It's not a partisan thing to say that. I think that, but I think the answer, at least in my view, is to try and force more of this obstruction out in the open. Yep. Now, Brandeis once said, sunlight's the best disinfectant. I tried to use that with my 3 kids. It doesn't work so great, but I think his point is still extremely well made, which is that if you bring a spotlight to this, people will be less likely to engage in, let's say, shameful tactics. And I think that may be, my hope is for the generation coming up, that they can live whatever public lives they want to live and fight for the issues they believe in and not feel that they're going to be punished. I might just add in closing, even when the author of that OLC memorandum was threatened shortly after she had that memorandum published on recess appointments by Senator Grassley, who said, I hope she never comes back before this committee again, because I'm going to then obstruct her nomination because of that, even though one might think she was simply trying to do her job. And putting that aside, it's not just people in OLC, it's people everywhere in public life who I think face the prospect that if you take this position publicly, it may come back to punish you. Now, that does happen in politics, but at least it's better if it happens openly than if it happens in a back room.
I just want to second the OLC part of this, because I think that OLC is one of the extremely important institutions we have for the rule of law, and it has not had happy days in the last 10 years. There was a time when the OLC nominees would be persons of considerable distinction, definitely politically loyal to the president, and that is an important point, but who have reputations outside of government that they're not going to sully. Now, the first point's important too. If the Senate tries to force somebody who's not politically affiliated with the president in that position, the president is going to find other places to find legal advice. It has to be somebody that the president trusts not to be, politically hostile. But it also has to be somebody who, if they sign something that is disreputable, will pay a price professionally and in terms of the rest of their lives. And this means they have to be confirmed. It's terrible that we went so long in the last administration and the first part of this administration without a confirmed OLC. And just one other point, this also relates to the unfortunate increase in power of White House counsel, which is not institutionally the same role. That role is supposed to be the president's lawyer. The OLC is not the president's lawyer. The OLC is the United States lawyer and the executive's lawyer, but is an important check. Since I've been involved in these things off and on, for quite a while, I've just seen a steady erosion in the prestige of OLC and a steady increase in the power of White House counsel. And this is not something that is good for the rule of law in America. Too many things never get to the courts. Now, maybe that's a good thing, or maybe that's a bad thing, but they're just objectively speaking, there are a lot of legal questions that are never going to get to the courts. OLC is our answer to that, and it has to be, there has to be the right kind of person there to do the job properly.
Let me say about OLC, that OLC has probably about 24 attorneys, and I think there's been a change over decades. I think there used to be more careerists. Now, it's true you only have the head of OLC and your deputy OLC is considered the political ones, and they come in and out every couple of years, but so do most of the other OLC attorneys. There are only 3 OLC attorneys who I would call careerists, having been there for 10, 15, 20 years. Only 3 out of 24. So otherwise, OLC has now become a place to burnish your resume. You've served at OLC for a year and a half, and you move on. So I think, Neil, you have a better history on this.
Yeah,
but I think
actually,
more
I'm pretty
careerists.
sure that's not different. The attorney advisors have typically turned over every 2 to 3 years, and
Okay.
that's going back to the 70s and 80s.
It weakens it then. I think it weakens its credibility to have that kind of turnover.
Right, and just one last point on OLC. When Dawn Johnson was nominated, the Wall Street Journal ran an op-ed opposing her nomination entitled "Gulliver's Lawyer," and the theme of the op-ed was that Dawn Johnson should be opposed because she would tie the president's hands, would tie the president down with that pesky law thing, instead of empowering him to go out and do whatever he wanted, right? And that should be a view that just can't be taken publicly. That should not be a credible grounds for opposing anyone to head the Office of Legal Counsel. That's exactly what the head of the Office of Legal Counsel should do.
And if I could just echo the point that that I believe the country would have been better had we had a full debate on Don's nomination. And what's happening is, and that the institution of the filibuster is good because it ensures that full debate, if that's what it's used for. And if it's used for mindless obstruction, then we don't have the kind of debate that we need. And we really have to figure out how to both make it politically unwise and politically unacceptable to simply filibuster by routine, and save the use of the filibuster for the important debates that the country really does need to have. And I think there actually may be a fair amount of agreement that we could get there. I actually think the idea of doing something that has future effect probably is more realistic politically, but I think it's something that we need to do.
Yeah, Glenn?
Thanks. Yeah, Glenn Cicomelli. Just one point about illustration of how absurd this has gotten. In addition to Senator Coburn, Republican Oklahoma, saying that it would be stupid to hold up circuit court nominees this year, his latest statement is that Robert Bacharach for the 10th Circuit could be cleared later this year if President Barack Obama wins re-election. If not, Coburn said, Bacharach would make a great nominee for a Republican president. So we should wait a year to figure out who gets to renominate Bacharach before he's confirmed. Is sort of like an onion piece. But just one other point about there was one attempt to, which actually did sort of succeed, to cut back on secret holds. I mean, Judging the Environment website, I've collected a lot of the senator statements, editorials, et cetera, to try to get rid of secret holds that people would supposedly have to come out and at least say who was doing it. That theoretically is true, but it doesn't happen because of details which don't need to go into right now. But just a couple of questions about things that could maybe make some changes. One, for example, is the cloture petitions have to actually be signed by a number of senators to actually get a cloture vote. But yet a filibuster threat does not. It's just one hold, one senator. So, I mean, kind of along the lines of what Senator Merkley's and Tom Udall are doing is saying you have to have a certain number of senators to actually threaten a filibuster, not just one hold. Another idea is blue slips have not always applied to circuit court nominees. Right now, for example, the Georgia senators have said that Jill Pryor would be absolutely fine for a district court nomination. She's then nominated to the circuit court, gets unanimously well qualified from the ABA, and they say we won't allow that. So it's obviously not her qualifications they're objecting to. It's that they want to be able to pick everybody for exactly which slots they get from there. So who gets the circuit court slot, who gets each district court slot, et cetera. They want to nominate, and the president needs to advise and consent, I guess, sort of making the switch on the Constitution. And another idea would be whether filibusters should be allowed for district court judges. They have not been a single successful filibuster of a district court judge. There was an attempt to do that for Jack McConnell, Obama nominee for Rhode Island, and there was a cloture vote which succeeded, and he was confirmed. So there have been a number of filibusters since, people held up since, but none of them have been successfully filibustered. And if that's true, then really all the holds are doing and the threats to filibuster is delaying all these district court nominees, forcing the Senate to perhaps waste an incredible amount of time, which they don't have, unless they want to drop other priorities. And maybe, that would be one solution which might help break the numbers loose. So if you're limiting filibusters to circuit court nominees where you have a large number of senators who really oppose them, and they have to actually come out and do it, I think you could then have discussions over whether particular nominees should be confirmed or not in that context, but you wouldn't shut down the system like the soaring number of vacancies we have now. Any thoughts on that?
I'm just not impressed by the argument that the Senate has too much to do to vote on judges. I think it's an important business. They could maybe put off voting for National Pickle Week till some later time. But the thing is that if you do not establish that you will bring your nominees to the floor, then of course the other side is going to take advantage of that. You need to be tough. So use some time, make them go all night, do it. And if Harry Reid actually showed the Republicans that he'll bring these nominees to the floor, the other side wouldn't get as much mileage out of trying to stop it.
I actually, yeah.
Sorry.
I actually really do agree with that. The times we made progress is when the Senate leadership has dug in and said, we're going to take these votes. I do think one change that could be helpful, there's no reason to have 30 hours of post-cloture debate on a nominee. That 30 hours of post-cloture debate is so that you can spend time on amendments to legislation, and you can't amend a nomination. So one way to really cut down the ability to tie up the Senate unreasonably once you've got your votes for cloture is just eliminate that 30 hours. And I think that could help streamline the process and make it less onerous if, in fact, you get cloture to spend the amount of time it currently takes to run through that time.
There seems to be little doubt that one of the dynamics here is if people don't think the president, or for that matter, the Senate Majority Leader, are going to fight for particular things, they will then obstruct. And that has been a dynamic we have seen for a while. I think it's explained politically to some extent, but there still is a cost to it. And the cost, obviously, is we've got vacant judgeships, and sometimes we have injured reputations, and even other problems as well. But I think that one of the things that may just be the simplest reform of all, and people have pointed this out, is a willingness to fight. Just a willingness to sort of take off the gloves and have a very serious fight, not over ideology, but over qualifications. I mean, these nominations, as people have been pointing out, can be defended quite well on merit. And just to almost come full circle, one of the things that I think sometimes people forget is the difficulty that politicians might have sometimes in reaching consensus on merit. Because I think politicians to some extent care more about ideology than merit, but I think if we can shift that debate, shift the focus over to merit, qualifications, and then have a fight over that, that could be one of those things that could open up the floodgates to some extent. But we haven't seen that. And I don't know if the next president, whoever that is, would be willing to do it, but that would make a difference right there.
Okay, yeah, I understand there's a question over here, but I can't see because of the
Right.
light.
We're completely blinded in this direction.
So my question for Mike McConnell and for Lou Fisher, in your view, is it entirely possible that by carefully doing the recessing, that the Senate and, if Mike is right, the House in combination can prevent the president from ever exercising his recess power of appointment, leaving aside the question of whether these were proper exercise or not? Because if you take the rules point and the House has to adjourn point, it seems to me that they could nullify the president's power to do recess appointments by just making non-recess recesses forever.
I don't think you can nullify it. It's a constitutional power. There's some cost to it for any president who abuses it, but you can't prevent a president from making a recess appointee.
Well, you can prevent it by never having a recess, is Alan's point. And I think, I think the answer to that is almost, because I do think that there is going to have to be a recess, however brief, nanosecond, between sessions. You can't eliminate that constitutionally. President Theodore Roosevelt nominated, I believe it was 106 folks by recess during the nanosecond between the sessions in 1903, if I have my dates correct. But the other thing is, I don't find this troublesome. The recess clause is a response to technology of the 19th century. It was, in those days, the Senate really was away for 6 to 9 months, and then they would come, and they didn't have recesses while they were in Washington. They actually sat, and we no longer have recesses. It's just they don't exist anymore. And so the need for the recess appointment clause simply doesn't arise. Instead, the presidents, beginning, a long time ago, have used the clause not for its real purpose, which is to name nominees when the Senate really isn't there, but as an end run around the requirement of advice and consent. I think if we were designing a constitution for the 21st century, we wouldn't have a recess appointment clause anyway, not if we really believe in advice and consent.
I'm afraid we have to stop here. We're out of time. Before you leave, I am told to remind you to please join us for the closing plenary, the resegregation of America, race, and the Roberts Court immediately following lunch. And then I'd also like you to join me in thanking our panelists for a terrific discussion.